Welcome to the Jill on Money Show. It's Saturday, May 11th, and this is the program that takes the mystery out of your financial life, and we do that in very specific ways. We ask you to do a little work. Go to our website, jillonmoney.com, click the Contact Us button, write a question, and then send it off to us. If you'd like to join us on the air live, just check that box. Mark does everything else. And don't forget to check out all the great content that lives on the website. There are blogs, there is a resources section, and the free weekly newsletter, which comes out every single Friday. Mark wraps up all the big stories of the week, or maybe not even the big stories, the stories you may have missed. Today, we are joined by Pamela Pirone-Benson. She is the Vice President of Advanced Planning at Fidelity Investments, and this interview is a paid sponsorship by Fidelity Investments. Today and tomorrow, we are going to talk to Pamela about how to have hard conversations about estate planning with your family members. Today, we're going to start right off by talking about why it's so important to name beneficiaries. Here's the first part of our interview with Pamela Pirone-Benson. Why am I talking to you? What makes you the qualified estate planning queen?
It's a good question. So here at Fidelity, I work as part of an advanced planning team, and we help our clients. We give them guidance and education on family wealth strategies, estate, trust, gift. Sometimes I like to joke, death and taxes, depending on what your family wants to accomplish. Here at Fidelity and with Fidelity Wealth, we want to make sure that we've had that as part of your discussion. It's important to think about when you want to pass wealth on to heirs, how that's incorporated into your financial plan.
You don't have to convince me, sister, because I am the biggest nudge in the world. So if you are a fan of the show, and everyone listening knows that I make people crazy. I almost I guilt them into getting at least taking a step forward before they join us on the program, because I literally will say every day, do you have your estate docs done? And I guess I am continuously flummoxed by this idea of the resistance to getting this done. What, in your experience, is the hurdle here? Is it just like, oh my God, I can't deal with death? Or is there something else behind it?
No, I think it's two things. Nobody likes to see lawyers, right? So a lot of times you have to go see an attorney.
I'm married to a lawyer. I love seeing a lawyer.
I am a former practicing one. So now, you could dislike me, I guess, or you could like
Never.
me. But, as before we get started, I think it's important to know that as we're talking about legal stuff, right? I want to mention Fidelity doesn't give legal or tax advice, and nothing we speak about today should be interpreted as legal or tax advice. The information I'm going to give you is general in nature. It may not apply to your exact situation. And if you have legal or tax questions about your situation, I encourage you have to talk to your tax professional or that attorney.
Good. Very good. You covered your ass. Okay. Yes. Now, why are people not doing this?
It's a good question. I think that death is a conversation that nobody really wants to have. Right? They don't want to talk about documents. It's more fun to talk about what they own and if their, assets are growing. But it's really important for people to think about estate planning. It sounds like you're a big supporter of it as well, which I know you are. I've heard you speak about it before. The other big issue is, well, I don't have enough wealth to have to worry about estate planning.
Right. It's like people say, all of a sudden it's like, oh, well, I'm not going to die. Well, no, but it seems to me like I really thought that going through the COVID era would cure people of this, where, we're trying to remind you that it's not just about passing your wealth to heirs, which is great, but it's also about the decisions that have to be made, sometimes in a way that is not easy peasy, that there are some hard decisions that could need to be made. Do you think that people are convinced of that when you're talking to folks, when you talk to a Fidelity client and you say, well, you might not think, but do they then kind of say, oh, well, that makes sense? Or they say, nah.
Yeah, no, I think they do get on board when we talk about things, but you illustrated what I try to talk about, which is it's so much more than just sticking a beneficiary and you die, somebody else handles it, right? If COVID taught me something, it was how many people didn't realize that estate planning actually starts with you, right? If you're incapacitated, what documents do you have? We had clients calling us, my spouse is sick. Can you help me? Can I take a distribution? No, right? Because without a power of attorney, you don't have the legal authority to speak on anybody's behalf. So I'm a big proponent, Jill, of all of us, no matter what your wealth is, no matter if you're 100 or, 25 years old, you should have the core 4 documents. Power of attorney, somebody that needs to talk on your behalf if you're incapacitated, pay your bills, run your life, make your financial decisions. If you don't have it, the state's going to appoint somebody over you, right? Or it's going to be expensive. Healthcare proxy, right? Put somebody in charge to make your own medical decisions. Your living will, what do you want, right? You want to be buried? You want to be cremated? Make that decision and definitely have a will outlining where you want those assets to go and choose that executor.
Now, I want to just say one thing about that living will, or I guess sometimes it's considered like the side letter. Or it's called different things in different states. But that idea of putting down your end of life wishes can be especially important if you are if you would like something to happen to you that is contrary to the way you've been raised. And I can't stress this enough because I've been around a few different estates, so that if you're someone who grew up in a traditional home where nobody's ever been cremated, you really want to be cremated. I know this sounds kind of ghoulish, but like, don't have some weird fight erupt, and you're not there to defend your actions or put your spouse or a loved one or a dear friend in that position. So I think that's huge.
It's huge to bring people together too, right? I can remember it haunts me where I was at a deathbed with a client when I was, back in the day, and nobody saw eye to eye. And that living will, I said, could somebody read this? Because this person took the time to put down what they wanted, and it helped bring people together, because not everybody's going to agree. You're right.
Okay. So let's just talk a little bit about the will, because we get a lot of questions about an executor. Somebody who said, like, we had somebody who came on the show once who said, I'm my ex-in-law's executor. The son and the daughter-in-law got divorced, and they were like, we don't trust him. We're making you the executor. How important is it to have a conversation with the person before you say, I'm naming you executor? Because I think some people get kind of shocked that they're the executors.
It's a good point in general that what good is your estate plan if nobody knows it exists, where to find it, right? We've had a lot of kind of in the media, famous people that they can't find their wills, they can't locate anything. And then secondly, if you're going to name somebody, it's probably a good idea to tell them, have a conversation. Recently, I had a client who named a child as their medical proxy. And when they spoke to the child, the daughter basically said, I'm just going to leave you on machines until, you naturally expire.
Oh,
right.
Geez.
So you got to know different personalities and understand, right? Executors have time deadlines, filings. They have to deal with taxes. If that's not their thing, probably not a good person to name.
So I'm just closing out 2 estates as a executor, and
sorry for you.
Thank you. I appreciate that. And I just want to be clear that the job of executor, I think some people may not be clear about what the role is. So the executor is the person who, fill in the blank, Pamela, what is an executor's role?
So the executor is the person that gets the job to settle your estate when you're gone. But a lot of times people equate, and it's okay to equate an executor to probate, right? Going through court, that word of going through probate. But as you've probably seen now being executor, not everything goes through probate, right? And that's based on how assets are titled. So if something's got a beneficiary on it, the executor really doesn't have to be involved by that. The asset would pass by beneficiary. So it's that person that gets the job to settle your final affairs.
You don't have to do it alone. Hopefully, whoever you've named as an executor can work with a team of people who can help you along the way. So how do we avoid some of those crazy zigs and zags in the process?
Yeah. So I think the first thing you said was build a team. Certainly important, right? You don't have to do it alone. You should have your attorney, your accountant, your financial advisor, right? Build that team around you to help you. Have a good list so that somebody knows where all of the assets are. And then think about probate versus not. This is a big one for me, where sometimes the objective is to avoid probate, avoid going through court. That's great. Then you have to put a beneficiary on something and it passes by beneficiary, or it can pass by operation of law. Maybe you own something joint with rights of survivorship. But with that being said, keep in mind that anything you put a beneficiary on is overriding what you did in the will. So if your will has a trust, or if your will says you want it to go to 8 people and that beneficiary says 1 person, well, now that 1 person's getting the entire pot. So I hear you. I think it's great to be mindful that you can put beneficiaries on certain assets. Just make sure you update them and it reflects your wishes. And maybe you don't have that ex-in-law, son-in-law as beneficiary on that page.
I mean, so one of the things that's weird in this process, and I'm sure you've seen it, is I think a lot of parents are flummoxed by this idea of splitting assets equally versus being equitable. And I get this from a lot of different listeners who hear these conversations and then kind of sidebar, send us a note like, well, one of my kids is a complete screw up. The other three are fine. What should I do? In some respects, I wonder if there is some advice around if you're worried about one of your children not being able to really manage assets. How do you see that?
Yeah, so I think there's a couple of things that we think about when you have different personalities and different children, right? And we have to introduce trust into the mix. That's the way to do it, right? So think about each child or each family member differently. And then we have to think about what are you trying to accomplish, right? For some, it's bloodline, going down the bloodline. For some, it's, well, they could get divorced, they could get sued, right? Different kind of malpractice issues. So you have to think about kind of that structure. And then you have to introduce trust. There's a lot of different kinds of trust. I know we didn't get into it yet, but the one that comes to my mind is a testamentary trust. That's a fancy word for a trust that just comes to life when you die, right? If I die and I have a minor kid, I can't leave a minor child money. I have to have a trust. So same with clients setting up a trust to not enable their kids. A lot of parents share with me, well, if I leave them X amount of dollars, I don't want them sitting around. I want them to be, upstanding adults. I want them to work. So you can have that trust set up. If you're going to do that, though, Jill, the most important thing is to think about trustees. I've had so many clients then say, oh, I'll just name their sibling on as trustee of the other sibling. Probably one of the worst decisions you could make, because now every decision is not, I'm your sibling, it's pulling the purse strings on your siblings. So a testamentary trust, some type of trust would be a good vehicle to outline those wishes.
The thing about a trust is there's two kinds of trust. There's a revocable trust and there's an irrevocable trust. Revocable, changeable; irrevocable, not changeable. So I just want to talk about the revocable for a moment. So, people have trust for lots of different reasons. There's kids, there's certain types of assets that are good for that. How can people understand whether or not a trust is worth it in their situation, a revocable trust?
Yeah. So I wish I had $1 for every time in 20 plus years of doing this, somebody said, do I need a trust? And I think where we have to take a step back is not everyone needs a trust. It's what you're trying to accomplish. One of the more common ones that you just mentioned is a revocable living trust. Exactly what you said. It's revocable. It's your social security number. You control the trust. You're the trustee, which means when you die, it's part of your estate. And during your life, you can use the money. It's generally broken down into 3 sections. You're healthy. You're fine. You do what you want. You're sick. Somebody is a trustee. They step in and help you. And then you pass away. It looks just like your will. Why do people set that up? I'd say 2 main reasons. One is to avoid probate. So in some states, we hear a lot about that, right? Some states, probate can take years. It can be expensive. It can be time consuming. People have to show up in person. They have to file a lot of paperwork. The revocable trust can avoid that. And the second is definitely privacy, right? If you don't want that will filed and it's public in some states where somebody can see who you left to, the revocable trust gets you that privacy.
Pamela, if you have a revocable trust, right, and then you pass away and then it becomes irrevocable on your death, right? Now it becomes sort of ironclad.
Yep.
Is that an asset that is held in that trust? Is that protected if there is some kid, cousin who wants to make a claim against the estate? Can they actually go after an asset in a trust?
Yeah, it's a good question. And the answer is yes, right? Nothing is foolproof. Somebody can make a claim. You have to have a valid claim, right? Of course, maybe there's a couple of things, undue influence, right? Fraudulent conveyance. So you have to be able to prove something. And we all know that litigation is, you can't stop somebody from always filing a claim. That's why some of them go away sooner rather than later. But that revocable trust does avoid having to be filed in court and somebody kind of being put on notice where it's kind of more in your face. It's not foolproof. Nothing is foolproof. Better to have it in writing than not. That's the key here, right? If you don't put it down at all in anywhere. But the revocable trust can keep you out of court, which is generally preferred in most states.
Staying on trust, an irrevocable trust, which is used for lots of different reasons. Sometimes it holds a big fat insurance policy to pay future estate tax. I only wish that everybody needed that for right now because of taxes and stuff. Like I wish your estate was big enough to need that, gang. But also, I get a lot of questions from people who say, well, this elder care person told me to move my house into an irrevocable trust. Now, first of all, could you explain the rationale behind it and sort of the advantage and disadvantage of doing something like that?
Sure. So the first thing is, if you're going to play in the space of any of this, but specifically irrevocable trust, you have to have legal advice. There are so many different kinds of irrevocable trusts, right? An irrevocable trust that's out of your estate that, for example, doesn't get a step up in cost basis. You buy the house for $100,000, it's worth $1 million. Some irrevocable trusts don't get that step up when you die. Some do. So it really depends on the powers that are within the trust. Some irrevocable trusts let you have income. Some don't, right? Again, depending on what you're trying to accomplish. So there's a lot of different kind of ranges of irrevocable trust. One side is what you mentioned, estate taxes, right? So let's keep in mind, we've got an estate tax exclusion right now of $13.6 million at the federal level that's coming down, right? So some people are setting up irrevocable trusts to accomplish that. But on the other side is this Medicaid, elder law protection.
Yeah.
So why people do it is they are afraid that if they get sick and they have to go into a nursing home, if they put their house in this irrevocable trust, and depending on where you live, it could be 3 years, it could be 5 years, state versus federal. If they get in the nursing home, they will not come back and take their house. I think the problem most often with that is you really then have to see, are you going to qualify for Medicaid from an income perspective? So just putting your house in the trust is not always good enough. So thinking if you're really going to qualify, you should talk to an attorney about that. I think the other thing is, do you want to be in a nursing home that's Medicaid approved? I think a lot of people might look at their assets, do a good financial plan and say, well, I can self-insure. They might have a lot of life insurance or long-term care insurance as well. So a lot of different things to consider with the irrevocable trust from the Medicaid perspective. One other thing I'll mention,
I want to just say one thing. I want to
Yeah.
say one thing that you won't say to everyone listening.
Sure.
Be careful with this.
Yeah.
There's a lot of how can I say it? Less than forthright people who are selling some of their services and wares to convince you to draft onerous and expensive paperwork. And, it might be an attorney, but they may not be giving you the full enough picture. That's why I think one of the coolest things that, when you have a team, when you have your team assembled, when you're, trying to figure out what do I want next, to have an attorney, to have a CPA, to have a certified financial planner, to have a team together that can look at your whole picture. And if you're at all anxious about this, or somebody's told you to gift your house to your kid, just sign it over to your kid. Do me a favor. Give us a holler. Go to JillOnMoney.com. Hit the contact us button. We need to talk this through. And you need a big team, not a big team, a team of professionals. Because Pamela, I think what you see all the time is that people they make these choices and they're not informed about the full picture and what could be ways to accomplish the same thing without the paperwork, without the cost. And some of this is really unnecessary.
And understanding what are you trying to protect against, right? With Medicaid planning or an irrevocable trust, that doesn't cover long-term care if you have to go into just an assisted living. We're talking about nursing homes. So I think that's something also, again, with your team, definitely get the proper legal and advice to make sure that you know what you're getting into.
All right. Now, here's another set of questions that we get all the time. Okay. We'll talk to people doing, obviously kicking butt, incredibly successful, getting ready to retire, have plenty of money, and they'll constantly be like, well, wait, what should I leave to my kid? Is it the house? Is it the Roth? Should I try to leave an investment account so they get a step up in cost basis? So I know it's different for every kind of person. Talk about the types of assets and how you transfer them to heirs and some of the things to consider before you make these big decisions.
Yeah. So I think, again, considering taxes would be one of them. Right. So that's a big one. Let's take an IRA, for example, right? When you pass away, if an IRA is going to a spouse, they'd be able to stretch it over their lifetime. If it's going to a child, we're now under what's called the Secure Act, which is a 10-year liquidation. So, are we thinking about, should it be a spouse? Should it be a child? Very different tax ramifications there. Assets such as a Roth account, for example, or any asset that receives a step up in cost basis. Life insurance, you want to think about. A lot of times, clients might consider giving that directly to children. But you do have to keep in mind the estate tax as well when you're thinking about who you're leaving to what. I always say we get to live our lives, we pay taxes, and when you die, there's a price to die as well, right? That estate tax. And that estate tax, if you're leaving to a spouse, for example, there's an unlimited deduction. There may not be any tax when you're leaving it to a spouse, but when you're leaving it to somebody else, there could be. So it's a good question, Jill. I think it differs from person to person for sure.
Okay, that was the first part of our interview with Pamela. She'll be back tomorrow. For more information, you can visit fidelity.com/wealth. As a reminder, this interview is an advertisement brought to you by Fidelity Investments. The views expressed are as of the date indicated and may change based on market or other conditions. Unless otherwise noted, the opinions provided are those of the speaker or author as applicable and not necessarily those of Fidelity Investments. Fidelity Brokerage Services, LLC, member NYSE, SIPC. Don't forget to do something nice for someone else today. Change your work, change your wealth, change your life. Thanks for listening, and we'll talk to you tomorrow.